Case 25, Hodges versus Delta Airlines. For this case, we find ourselves at the U.S. Court of Appeals for the Fifth Circuit. Facts. During a flight from the Caribbean to Miami, Francis Hodges was injured when a fellow passenger opened an overhead compartment and dislodged a case containing several bottles of rum. The box fell and cut her arm and wrist. In her lawsuit against Delta Airlines, Hodges alleged that the airline's negligence caused her injury and medical expenses. So what's the issue? Whether the state law tort claim for physical injury based on alleged negligent operation of the aircraft is preempted by Section 1305 of the ADA. Holding. Hodges' claim is preempted, and the judgment of the district court should be affirmed. Let's discuss the reasoning for this. Let's start by defining this new term, en banc. In law, an en banc session, French for in bench, is a session in which a case is heard before all the judges of a court, before the entire bench, that is, rather than by a panel of judges selected from them. En banc review is often used for unusually complex cases or cases considered to be of greater importance. Given the importance of preemption in aviation law, it is important to spend some time making sure you grasp this question. State law is displaced by federal law, where 1. Congress expressly preempts state law, 2. Congressional intent to preempt is inferred from the existence of a pervasive regulatory scheme, or state law conflicts with federal law or interferes with the achievement of federal objectives. Interpretation of the statutory language is the key to construing its preemptive force. Morales commands that whatever state laws relate to rates, routes, or services are broadly preempted, but it does not define services. The panel opinion in Hodges concluded that services generally represent a bargained for or anticipated provision of labor from one party to another. If the element of bargain or agreement is incorporated in our understanding of services, it leads to a concern with the contractual arrangement between the airline and the user of the service. Elements of the air carrier service bargain include items such as ticketing, boarding procedures, provision of food and drink, and baggage handling, in addition to the transportation itself. These matters are all appurtenant and necessarily included with the contract of carriage between the passenger or shipper and the airline. It is these contractual features of air transportation that we believe Congress intended to deregulate as services and broadly to protect from state regulation. The FAA further defines operation of aircraft as the use of aircraft for the purpose of air navigation, including the navigation of aircraft. 1 uses the overhead luggage racks or the food and beverages provided in aircraft operation, just as 1 uses the cigarette lighter or built-in cooler compartment in an automobile. And all these devices are available to support the general purpose of navigation. Significantly, 2. Neither the ADA nor its legislative history indicates that Congress intended to displace the application of state law tort to personal physical injury inflicted by aircraft operations, or that Congress even considered such preemption. According to the court, this silence takes on added significance in light of Congress's failure to provide any federal remedy for persons injured by such conduct. It is difficult to believe that Congress would, without comment, remove all means of judicial recourse for those injured by illegal conducts. The Supreme Court has repeatedly cautioned that federal courts should not displace state police powers by federal law unless that was the clear and manifest purpose of Congress. Meanwhile, the Seventh Circuit noted that state courts award damages every day in air crash cases, notwithstanding that federal law preempts the regulation of safety in air travel, confidently adding that the Federal Aviation Act does not expressly preempt state damages remedies. Delta Airlines agreed that among the services deregulated under the ADA and covered by its preemption clause are the economic or contractual features of air transportation. Delta argued, however, that Mrs. Hodges' accident arose out of the services of baggage handling and boarding, not out of the operation and maintenance of aircraft covered by Section 1371. The services that the state may not regulate under 1305 are distinct from the operation and maintenance of aircraft, and all claims related to services are preempted. This argument failed on two levels. Number one, if the statutory provisions created a strict dichotomy between services and operation or maintenance of aircraft, Hodges' injury more properly is laid at the door of operations. Whether certain luggage may be placed in overhead bins and whether the flight attendants properly monitor compliance with overhead rack regulations are matters that pertain to the safe operation of a flight. Baggage handling and boarding, as referred to in the above-quoted CAB statement, concern the airline's policy for permitting baggage to be carried or passengers to be permitted to board. These are aspects of the service offered. They do not refer directly to the way in which the aircraft is operated. Delta, according to the court, confused its argument by contending that this state tort suit should not be permitted to proceed because it would impose duties that conflict with FAA regulations governing carry-on baggage. There are no facts in the record that intimate the basis for such a conflict. Moreover, in Cipollone, the Supreme Court held that when Congress has acted in explicit preemption provision, courts should not usually imply broader preemption under state law. Therefore, this decision of our court does not address the possible preemptive effect of FAA safety regulations governing aircraft and carriers. Number two, the provinces of service and operation and maintenance of aircraft overlap somewhat conceptually. No strict dichotomy exists. There is not, however, a fundamental inconsistency between the two provisions. By means of Section 1305, Congress intended to prevent the states from regressing on economic deregulation by applying their own laws or rules concerning services. But in Section 1371, Congress explicitly preserved airlines' duty to respond to tort actions, inferentially state law actions, for physical injury or property damage. Finally, unlike the NAG guidelines in Morales, enforcement of tort remedies for personal physical injury ordinarily has no express reference to services as defined here. Enforcement of such tort duties normally will not have the forbidden significant effect on airline services. Morales relied in part on the fact that the state restrictions on airfare advertising had a significant economic effect on fares. Generally, however, state tort laws concerning the operation and maintenance of aircraft can be enforced consistently with and distinctly from the services that Congress deregulated. That Congress did not intend Section 1305 to preempt all state claims for personal injury is evident from at least one other provision of the remaining airline regulatory statutes. Air carriers are required to maintain insurance, or self-insurance as prescribed by the FAA, that covers amounts for which air carriers may become liable for bodily injuries to or the death of any person, or for loss of or damage to property of others, resulting from the operation or maintenance of aircraft. The importance of Section 1371 cannot be understated, for it can only be understood to qualify the scope of services removed from state regulation by 1305. A complete preemption of state law in this area would have rendered any requirement of insurance coverage nugatory.